before I address the main issue, let me make a few submissions on the controlled delivery. In 1988, there was a UN convention. Internationally, the illicit trafficking is a big menace. So to identify who are these people who cause this movement of these international drugs, this concept of controlled delivery was derived in a UN convention in 1988. Article 11 of that convention deals with that. Yes. As a signatory country, we have adopted that, and in 2001 we inserted that. Controlled delivery, Lord, is just one of the investigative tools which will help the authorities to identify. Otherwise, what happens is now in the last couple of decades, one of the easiest methods of ordering drugs is through courier. And when the authorities go to apprehend, they say, sorry, sir, I mean, I have never ordered this. I am not the person here, or I did not place an order. And that is sufficient in the criminal jurisprudence to escape the nose. Therefore, this concept of controlled delivery was used in order to identify the person. Now, Lord, I may use or I may not use. It is an option. Now, when your lordships pass the order, your lordships primarily refer to the grant of bail order. And the court which granted the bail noted that the mandatory requirements of 50A were not followed. Mandatory. But if I may read paragraph 13 of that judgment at page 10.
Yes.
Learned counsel appearing for the respondent has failed to demonstrate before this court that the officer who had undertaken the excise control delivery with the help of postman and the postmaster of Martha were authorized as per section 50A of the NDPS Act. In the absence of authorization as provided under 50A of the NDPS Act, which is the mandatory requirement of law, it cannot be said that the exercise of controlled delivery undertaken by the NCB officers had successfully led them to identify the persons involved in the commission of the offence.
What is the difference between that accused and this accused now?
Both of them were involved. They all connived together. They were all one.
No, what has happened to this judgment?
On 2 minutes, just 2 minutes.
Yes.
I'm trying to develop an argument.
Yes.
Then it says the NCB officers have recorded so and so that we can skip lines. However, since the NCB officers have not complied with the mandatory requirements of section 50A of the NDPS Act before undertaking the exercise of controlled delivery, the report of the controlled delivery on which reliance has been placed by the prosecution cannot be considered, since the exercise of controlled delivery gets vitiated for non-compliance. Now, I perfectly bow down to this. What his lordship is saying is that if you have not complied with the mandatory requirement of 50A, what gets vitiated is the exercise of controlled delivery. But my lord, where the error has crept is, please subordinate bench granting bail clearly holds that the Panchnama would indicate that the NCB has not complied with the mandatory requirement of section 50A before undertaking the exercise of the controlled delivery, and non-compliance of section 50A would vitiate the entire proceedings. My lord, the difference is, vitiating the controlled delivery exercise, I'm in complete sync. There is no difficulty.
That would not vitiate the entire proceedings.
So, my lord, the lordships have held that infallibility is not unknown to humanity. Fallibility is not alien to the judicial process. So therefore, not what I thought was...
this is a student, I guess, who will go back to custody.
These are all serious offences, my lord. They are ruining the society. Your lordship should not shed a tear for such, my lord. These are all serious offences. My lord, this leads to denigration of our youth, who are the future of our country.
I understand, because
the submission that I am making
this man, I don't know about this accused, but this, the accused was a student of the IIM. This is IIM student.
That is accused number 2. That is accused number 2.
He was a student of the IIM who was sent out because consumption, not distribution.
So, Lord, the evidence on record shows all of them connived together for the purpose of sale. We have got plenty of evidence on that. All that I'm saying is, my lord, I thought, my lord, your lordships are also laid down the law that while review is not permissible, a recall is permissible. Lord, instead of I've already instructed in the next 3 working days, my lord, we will present a recall application. Lordship will hear that first, my lord, and then
fine, we'll do that.
Lordship,
so you're basing your foundation is this order.
My lord, my foundation is on law, section 50A.
50A is not complied.
No, my lord.
No, the learned ASG said that if section 50A is not complied, it vitiates the controlled delivery process and not the entire crime that is registered.
I just want to read the sections once.
That's all. Yes.
I just want to read the section.
Please do. Yes.
My lord, first I'll read section 50A and then go back to section 27B. Section 50A, my lord, power to undertake controlled delivery. The Director General of Narcotics Control Bureau, constituted under subsection 3 of section 4, or any other officer authorized by him in this behalf, may, notwithstanding anything contained in this act, undertake controlled delivery of any consignment to A, any destination in India, B, a foreign country in consultation with the competent authority of any foreign country to which such consignment is destined in such manner as may be prescribed. Now, my lord, section 27B, I'll just... Controlled delivery means the technique of allowing illicit or suspect consignments of narcotic drugs, psychotropic substances, controlled substances, or substances substituted for them to pass out of or through into the territory of India with the knowledge, under the supervision of an officer empowered. This, my lord, is important. It has to be read in consonance with section 50A.
That is what is in violation is the coordinate bench judgment in.
Yes, my lord. And my lord, the entire...
The learned AG said, yes, there has been a violation of 50A in this.
I concede.
Conceded. Now, the violation of 50A will not vitiate the crime itself. It will only vitiate the controlled delivery process. Are you suggesting that the entire crime is registered on controlled delivery? If the controlled delivery process goes, the entire thing goes?
Yes, definitely, my lord, because my lord, may means the NCB officers could have undertaken controlled delivery or cannot. They have an option either to do it or to not do it. But once the intelligent officer has gone to the post office, has taken the parcel, has cut open the parcel. So, my lord, the object of the NDPS Act is number 1 to regulate. Number 2 is to combat the narcotic drugs. Now they've done this controlled delivery. They've cut open the parcel. They've identified me as an accused. If they would not have done that, everything goes. I would not have even been identified as an accused. So when they have not done that, I would have not been identified. So once they've taken the process of controlled delivery.
Therefore, the entire crime is registered on that controlled delivery.
Yes.
Of that parcel. And
yes.
That is in violation of 50A.
Yes, my lord. And my lord, there are 5 accused in this case. Accused number 1 and 2 have booked through accused number 4 and 5. Neither have I booked, nor have I purchased, nor am I into anything. I'm not even in the entire process. I am accused number 3. And my lord, my submission is, my lord, is this, that once they've cut open the parcel, only then they have identified me as an accused. Apart from that, there is no prima facie substance or any material on record to indicate me or make me as an accused. So they've gone ahead without complying with the statutory protection that the Act provides for me, as for accused number 3. Once they've done that, they should have complied with the provisions, my lord. Director General is the empowered officer under section 50A. They have gone ahead, done the entire process. They've utilized section 50A without maintaining the statutory compliance of what the section provides for, and section 2 subclause 7B. So once they've identified me as an accused, now to my lord, come and see.
Yes, sir. There's a point in what she says.
Lord, let me answer that.
If everything has sprung only from that parcel and
that's an incorrect submission.
Then what material do you have other than the parcel? What material do you have?
Other materials, the seized material, seized phones.
No, that is after that. The corroborative material is what you are relying on. The basis of foundation for complaint.
No, independent of the controlled delivery, I have got other evidences. Lord, the prosecution should be sustained on the basis of other evidence that have. Lord, 482 cannot be used by the petitioner to evaluate the strength of that evidence. Lord, that is settled.
The problem is there is already an order. That's the issue.
My lord, I just want to point out.
Lord, the other judgment, not the recall application, may be heard independent of that. And then this may be taken up. If my learned friend wants to argue that independent of that judgment, I am ready even now.
No, she's wanting to do.
No, I'm wanting to argue, my lord.
That's what she's done.
No, I mean,
I just want to point out one thing, my lord, within the bail order. I'll just pass on because I'm not.
Letter, yes.
And my lord, the threshold for bail and for quashing are way different. There is a world of difference between them.
I agree, my lord, and I agree to senior's argument saying it's an investigative tool. But when it's an investigative tool, they have an option to either to use it or to not use it. But once in NCB officers have undertaken controlled delivery, they must give me the statutory protection. They cannot just go ahead, cut open the parcel, identify me as an accused, and now to come and say that it's an investigative tool. Yes, it's an investigative tool, but to what extent? I am accused number 3. Your Lordship's order has attained finality. And my Lord, this bail order, Your Lordships may kindly see, my Lord, internal page number 7, para 5. So, learned senior counsel appearing for accused number 3. Same facts, and my Lord, the statement of objections that have been produced by, this bail orders with respect to the accused number 3 who's before Your Lordships now. And the statement of objections, my Lord, I'll get into that later, but para 5, my Lord, page 7. Appearing for accused number 3 submits that the parcel was opened in the post office by NCB officers even before apprehending any of the accused, and the contraband article allegedly found in the parcel was subjected to Panchnama. Thereafter, dummy parcel was delivered to accused number 2 and 3 respectively, and they were apprehended. My Lord, this part is important, where the court has identified and already gotten into this aspect that I was not even identified as an accused even before they cut open the parcel. So the fact remains that I would have not been a part of this entire case if they, or I would have been, but the point is that they should have followed the statutory compliance of section 58.
That is what.
And my Lord, otherwise, my Lord, I wouldn't have been identified as an accused. There is no other material for them to identify me as an accused. Only after they cut open the parcel, they identify me as an accused. They tell accused number 2 to go with the NCB officers and then to deliver the parcel. That's the chain, my Lord. Otherwise, the entire process would not have occurred. They wouldn't have even known. And my Lord, out of 5 accused, I had nothing to do with the entire transaction. Accused number 1, 2 have booked through accused number 4 and 5. And accused number 2 has paid for this narcotic drugs through crypto.
How did you come into the picture?
Only when
what is that material that was there for you to be dragged into the picture?
it was the name on the parcel, my Lord. They said that this
Name
needs
on
to
the
be
parcel.
Yes. So
Name on the parcel was yours.
name on the parcel was mine. But how did they get to know, my Lord? Only once they have started the process of controlled delivery. The one Mr. IO who's he's received the credible information that certain drugs have been sent from the post office. He has recorded that information, gone to the post office, informed the postmaster and the postal assistant. Requested them to be independent witness. So while he's doing all this, he could have just done one more thing, taken the authorization of the DG.
No, admittedly, authorization of DG is not there.
No.
No, my Lord.
That he accepts.
Yes.
My Lord, may I just pause here for a moment, because I think we will unnecessarily waste energy. If my learned friend says that we have filed the complaint only on the basis of the courier delivery, she is wrong. In fact, she has produced a copy of the complaint, the prosecution complaint. Please have a look at that complaint, which at para Roman 3, the complaint refers to Telegram chats. Similarly, it continues at para 4. The transcripts of WhatsApp chats between the petitioner of Your Lordship and other one, so and so, it refers to the various discussion. And on the next page, from the above chats, after the portion that is in bold, from the above chats, it is clearly indicates the petitioner and so are into sales of HSD, LSD and other drugs. Instruct so not to procure that so. So it is not based on the parcel alone.
So even A3 was not, A3 was selling.
All of them, my Lord, discuss selling. All these accused have Telegram accounts where they discuss selling, and we have about 1,000 pages of the transcript, and their bank accounts also corroborates this. So the bottom line is, we have got evidence and proof which is acceptable in law, but I should be permitted to establish my case. If my learned friend's case is, number 1, she says once you undertook 50A, then you cannot proceed. Where is that law, my Lord? I do not find any such law. Let her furnish any authorities. Number 2, that my prosecution is only based on the courier. No, it is based on other proof. No, Lordship will envisage this situation. If this very petitioner had approached Your Lordship, if had not conducted the controlled delivery, would Your Lordship interfere? The answer is no. So therefore, the controlled delivery being only an investigative tool which I may or may not use, if I had not at all used, how would it, then Your Lordship would not have interfered, because my complaint indicates an offence. If we apply the Bhajanlal principles, my Lord, not a single of the 7 elements would be satisfied. The complaint clearly makes out a case. So I should be given an opportunity to prove improve in the trial.
My respectful submission, my Lord, I don't have to rely on authorities. The law protects me. Section 50A is the law, and as on today, the law it is the law that needs to be followed. If the argument is that your lordships would have not interfered if section 50A was followed, that's exactly my case. Now that it's not followed, your lordships will have to, since your lordship's order has attained finality, with respect to the very, and one more thing.
On following the law, I mean, I need to understand, when my learned friend says I have not followed the law, I need to understand what it is. If her case is that it was not authorized, my lord, I agree. So therefore, the control delivery process gets vitiated. But her proposition that she is trying to lay before your lordship is that once I initiate 50A, then I cannot go to other proof. It appears to me that is the proposition.
And just one more thing I want to point out, the WhatsApp chats that were just referred by my senior, just at page, the coordinate bench's order, my lord, at page 22, para 20, if your lordship. So now what's been relied upon is the telegram and the WhatsApp chats, my lord. I just want to point out.
Paragraph
20. Yes, my lord. From the reading of the voluntary statement of accused number 3, it is seen that the alleged WhatsApp conversation was with respect of a parcel which he had received earlier, and the same was kept by him near front of door window of a villa, and it was picked up by somebody. Therefore, it is very clear that the WhatsApp conversation of the extracts are placed on record by the prosecution do not relate to the present transaction. The learned counsel for the respondent has failed to demonstrate before this court that WhatsApp conversations are placed on record in any way relates to the present transaction and is not with respect to the earlier. There is, and my lord, the last part of para 21. There is nothing on record to show that accused number 2 and 3 knew the contents of the parcel which was ordered by accused number 1 in the name of the accused number 3. Accused number 3 is only the addressee of the consignment, while accused number 2 had allegedly transferred the amount through cryptocurrency account as per instruction of accused number 1. It is only the accused number 1 who knew the contents of the consignment / postal parcel, as he was the person who had placed the order through telegram. So this is already covered, my lord. This is all argued. And my lord, this honorable court has already quashed the proceedings with respect to accused number 2.
Parameters of examination, bail
and also, my lord, this was at the crime stage. The investigation was going on. FSL report was not there. Now, my lord, we have completed the investigation. We have the benefit of the FSL report.
We'll see.
And my lord, in my memo, just on parity, my lord, because I stand at a better footing. Accused number 2, my lord, was the one who booked the parcel, and your lordships have quashed the order quashed the proceedings with respect to that person. And my lord, had nothing to do with it. Only when I was identified as an accused and the parcel was delivered to me, they have made me an accused number 3 in this particular case.
That is not.
And my lord, Supreme Court, my lord, has held that once it's part of the memo. I'll just read that paragraph also. The principle of parity in criminal cases is that where the case of the accused is similar in all respects, which, my lord, in this case, it's arising out of the same crime number. I'm not even the main accused. I have not booked, I have not purchased, I had nothing to do with it. The NCB officers have very conveniently skipped the entire statutory protection that was supposed to be complied with. Section 50A, as on today, is the law, is not being followed. And so that's why, my lord, I'm relying on this case to say that in criminal cases, my lord, where the case of the accused is similar in all respects as that of the co-accused, then the benefit extended to one accused should be extended to the co-accused. With regard to this principle, it is important to mention the observation of this case and please, ma'am.
The statutory protection under 50, I have not understood what it is. My learned friend said
procedural protection.
Procedural protection.
I mean,
DG's permission had to be taken,
fine.
not taken.
I am willing to forego. I am willing to forego the activity of control delivery. My control delivery has gone to the dustbin now. I am not going to use it. But I have other evidence which should sustain my prosecution.
Let them also throw me also on the dustbin, my lord. Like let them forget about me, because I'm only the accused number 3 in this case and I have nothing to do with it.
Lord, we have to save this country. We are not going to do that.
No, that's not that. But by way of procedure, that's all.
By way of procedures, no.
Yes.
I'm relying upon a couple of authorities. The proposition is that error in investigation, my lord, there are 2 Supreme Court judgments. Error in investigation cannot result in acquittal. I am at a much lower threshold. Error in investigation cannot lead to even quashment. Number two, my lord, that I have referred to Niharika as well as Bhajanlal to show that I have made in my complaint demonstrate that an offence is committed, that is sufficient. The other parameters are not justified.
Learned seniors, the judgments, my lord, just a rejoinder to those the judgments that are relied. Now, those, my lord, my rejoinder to those judgments are everything deals with the fact that 50A is an investigative tool. I, for one moment, I'm not saying that it is not an investigative tool. My submission, my lord, is this. It is an investigative tool. The NCB officers have the option of either going ahead with it or not.
You told me. Yes.
Please, my lord.
The Delhi High Court, my lord, refers to 50A as a directory, not mandatory.
That is, we'll
But-
consider.
But my
We'll
submission
consider
is, my lord,
everything, and
it
if
is.
in case I've committed a mistake in that, we'll try to rectify.
Anyway, I'll file that application also.
Yes.